Good day to you and welcome to another Paddocks Club video tutorial. Today I want to deal very briefly with a misconception which arises from time to time in sectional title management. The misconception I speak of is that the body corporate or an owner's responsibility and their legal liability to carry out repairs and maintenance depends on the fault of that responsible person, and that they only are liable to carry out and pay for the repairs if they cause the problem which needs attention. Now, this is just not the case. The liability of the body corporate to repair and maintain the common property in a scheme is not fault-based like a delictual liability. The body corporate doesn't have to fail in its duties to repair or maintain or be negligent in some way in order to become liable to attend to faulty common property. This liability arises not because they've done something wrong or the managing agent has done something wrong or failed to do something, but because the Act imposes an unqualified obligation on the body corporate to maintain and repair the common property. So this obligation exists irrespective of the cause of the problem. Of course, if the body corporate can show that some other party is directly responsible for the problems that it has to address, it may have a claim against that party on the basis of their wrongful conduct, their act which caused it damage. But that will not excuse the body corporate from its unqualified statutory liability to carry out the repairs, maintenance, and where necessary, the replacement of the defective common property. In the same way, the liability of an owner under the Act to maintain and repair his or her section is an unqualified statutory obligation. So if there is damage to a section, the owner must repair it. Again, if the owner can show that there's a direct causal link between the damage to his or her section and the wrongful act of another person, for example, the owner of the floor above, who has failed to maintain his or her section and water has dripped down through, then the section owner can claim damages. But the primary legal responsibility to repair the section remains with the owner under the Act. Very often, this comes up in the context of the foundations of a building, which are pretty well always common property, and when they sag or fail for some reason, particularly when the building is a detached house, it isn't unusual for the trustees and managing agent to assume that the owner is responsible, but this is wrong, as you've seen. Another relevant consideration in this regard is the existence of the implied servitudes of support, mutual support, in terms of Section 28 of the Act. Whenever common property is capable of supporting a section, or a section is capable of supporting common property, vice versa, in other words, which is wherever common property and a section are next to each other as part of the same structure, whether the support is sideways or upwards. The common property must support the section and the section must support the common property. Again, these are unqualified legal obligations. They don't only apply when the body corporate or the owner can be shown to have been negligent or to have intentionally withdrawn the support. Thank you for joining me in this Paddocks Club tutorial, and if you have any questions, let's deal with them in the discussion forum.